G'day everyone, and welcome to the fourth and final video in week 2 of our legal ethics course. In the first 3 videos this week, we looked at the fundamental authoritative rules that bind legal practitioners in their practice of the law. So we looked at the Legal Profession Act, at the Australian Solicitors Conduct Rules, at the Barristers Rules, and we looked at the rules of court, including the inherent powers of a court to regulate what happens in that court. It's generally true that for rules to have any real bite, there needs to be some institution capable of enforcing those rules. So we've already seen that the rules of court can be immediately implemented by judges in those courts. But what about the rest of the rules? The solicitors' conduct rules, the barristers' rules? Who implements those? Because unless somebody implements them, well, the rules can just be ignored. For many years, the rules were enforced by the 2 professional societies. So the Queensland Law Society enforced the Solicitors' Conduct Rules, and the Queensland Bar Association enforced the Barristers' Rules. Part of the very purpose of the professional associations was to make and then enforce the rules for each side of the profession. The problem is, of course, from the perspective of an outsider, this all looks just a bit sus. It's lawyers judging other lawyers. Even though we understand that lawyers in that role are very likely to perform their role diligently, imagine if you were a lay person complaining about the conduct of a legal practitioner. You could hardly blame a person in this position for wondering if they're going to get a fair go. And so in 2004, legislation created the Office of the Legal Services Commissioner, now simply known as the Legal Services Commission. The Commission now operates under Part 7.1 of the Legal Profession Act 2007. The Legal Services Commission is essentially a complaints handling and an investigative body. So if clients of legal practitioners in Queensland have complaints about their legal practitioner, they're entitled to make their complaint to the Legal Services Commission, and the Commission will then decide whether to investigate that complaint. The vast majority of complaints made to the Legal Services Commission regarding practitioners are complaints about the costs charged by law firms. However, clients and members of the public generally are completely entitled to make complaints about legal practitioners and to have those complaints considered, then investigated if the Commission considers the investigation is justified. In addition, the Commission has the authority to conduct what are called own motion investigations. These occur when, through some mechanism other than a complaint, the Commission becomes aware of conduct by a practitioner that merits investigation. This might happen, for instance, if the conduct of a practitioner is reported in the media, or it might happen as a result of something viral on social media, or, not uncommonly, it might happen as a result of a judge referring the conduct of a practitioner in court to the Commission for further investigation. During the investigation, the Commission has very strong powers. Most notably, practitioners are required to provide full and frank cooperation with the investigation. Practitioners are not, for instance, entitled to remain silent. They have no privilege against self-incrimination. Section 553 of the Legal Profession Act requires persons to give reasonable help to an investigator, but the case law is clear. In the case of a practitioner, this means full and frank cooperation. Once the Commission has conducted an investigation, it has a range of options. If the Commission finds that there is no case to answer, the Commission can simply take no further action. Otherwise, at the lowest level, the Commission is entitled to resolve a matter informally or simply by providing advice to the practitioner. If that's not enough, the Commission can commence a prosecution in one of 3 different places. At the lowest level, it can prosecute in a body called the Legal Practice Committee, or it can prosecute in the Queensland Civil and Administrative Tribunal, QCAT, or it can issue a summons in the Magistrates Court. This last bit's important. The Legal Services Commission gets to investigate and prosecute. However, practitioners whose conduct is dealt with by the Commission, well, they're still entitled to procedural fairness. So it would be no good if the Legal Services Commission, having investigated them, also made the final decision. This way the practitioner may be defended and will get the fullest possible opportunity to put their case. Now, most of you will probably already be familiar with QCAT and the Magistrates Court, so in the next part of this video, I'm going to focus on introducing you to the Legal Practice Committee. To make sense of the Legal Practice Committee, I'm going to have to introduce you briefly to two terms you'll be meeting again at length later in this course: professional misconduct and unsatisfactory professional conduct. They kind of sound like the same thing, and in a way they are. However, in the spectrum of naughtiness that a practitioner might be guilty of, professional misconduct is all the stuff at the worse end. Unsatisfactory professional conduct is all of the stuff that's still not okay, but which doesn't rise to the level of evil of professional misconduct. The Legal Practice Committee only deals with unsatisfactory professional conduct, so the conduct that is not at the worst end of the spectrum. It can impose a range of penalties, including reprimands, fines, and conditions on the practice of a lawyer. These are still quite painful penalties, but not to the point of suspending someone's right to practice, let alone striking them off the roll. A decision of the Legal Practice Committee can be appealed to QCAT and then potentially to the Court of Appeal and even the High Court. Before we move on from the Legal Practice Committee, it's worth noting that the committee also has an advisory function on behalf of the community. It monitors the effectiveness of the solicitors' conduct rules and the barristers' rules, and it can make recommendations for those rules to be amended whenever the committee considers it appropriate. Now, obviously, no one wants to end up coming to the attention of the Legal Services Commission, let alone the Legal Practice Committee or QCAT or the courts. And yet the number and the seriousness of the rules can be quite bewildering. We haven't even really started looking at them yet, but there's heaps. And applying those rules in the complexity of real life makes it all even harder. Thankfully, there are resources that can help. At the simplest level, you'll be pleased to learn that for your first 2 years of practice, you're required to be supervised. We'll learn more about this requirement next week, but it means you'll have a supervisor to go to if your ethical spidey senses start tingling. Beyond that, we have a wonderful resource called the Queensland Law Society Ethics and Practice Centre. Any practitioner who is a member of the Queensland Law Society is able to contact the centre and obtain confidential advice from a solicitor there who specialises in the rules. This advice is given free of charge, and you're even allowed to discuss confidential client matters with them, and in the end, if necessary, they will provide you with something in writing, usually an email, to guide you in the resolution of your ethical dilemma. If there's any later suggestion that you didn't follow the rules, well, you stand in a very powerful position if you can show that you consulted with the Ethics Centre, that you were open and honest with them about the dilemma, and you followed their guidance. I have personally contacted the Ethics Centre more than once because I wanted something more than my own sense of conscience to guide my thinking. In addition, the Ethics Centre provides resources such as guidance statements about some of the more common ethical dilemmas. At the time I'm making this video, there are 29 guidance statements on matters as distinct as the ethical obligations of solicitors appearing in court by Zoom or similar technology, the obligations of solicitors giving second opinions, there's guidance on giving advice to family and friends, guidance on what you should do if you receive an inadvertent disclosure from the other side, let's say they send an email clearly not meant for you, there's guidance on how to ethically terminate a retainer, there's a bunch more. Finally, if you find yourself in an ethical dispute with another practitioner, the Ethics Centre will act as an umpire, giving what's called a non-binding ethics ruling, which will hopefully resolve the dispute and put everyone on the same page. The Ethics Centre is a fantastic resource. Please use it. Okay, gang, in week 2, we've looked at an outline of the rules. The Legal Profession Act, the Solicitors' Conduct Rules, the Barristers' Rules and the Rules of Court. You'll be seeing heaps more of those as we go through the course, particularly the solicitors' conduct rules. We've also looked in this final video at the mechanisms that exist to enforce those rules through the Queensland Legal Services Commission, the Legal Practice Committee, and I've introduced you to the QLS Ethics Centre, which provides great resources to help you make sound ethical decisions. Next week, we're going to start tackling actual ethical topics, beginning with the process of admission and the ethical assessments that the Admission Board and the Supreme Court will make before you're even allowed to practice. See you next week.